I appreciate you joining us. I know this is probably one of the last really nice days of the fall, so appreciate you taking the time. On the line, actually listening in, is Michelle Thompson, who's another attorney at the office in Bismarck. So Michelle joined us just within the last, I guess, 5 months, and so we're glad to have her. So she is there. So basic estate planning. Now, realistically, there's a lot to cover. In an hour, we're going to touch on issues. The idea is just to give you an idea of some of the items that can come up, maybe some things that you haven't thought about that are important in estate planning. The first aspect, I think that first part is so important. It's more than making a will. So many times people come to our offices and they say, well, I've got to make a will because, and they talk about things like, well, there will be estate tax, or the state will send our property to who knows where. It's more than making a will. Really what's going on is, as I said, it's coordinating what's going on with your life. For example, property. Do you own a house? Do you own a lake cabin? Do you own property maybe in Arizona? Cars, all kinds of different things that we're talking about. Retirement, insurance, investments, all of those are part of your plan, and many of them are not necessarily handled by a will. I mean, a will can do it, but there are other things that you can do to handle the transfers that you might want to make. So what are the big issues? Well, first one up there on the top is taxes. And I think you're going to find after we get done talking, it isn't as much of a concern as it was perhaps when your grandparents were looking at their estates. We're going to talk about asset ownership, which quite frankly is probably as important as just about anything in your estate plan, because we're going to find you need to know what happens if you own your property in this way or if you own it that way. Now, the will, I certainly don't mean to discount a will. I'm simply saying that a will is part of the plan. Trusts. We're going to talk about trusts. For many years, there's been a lot of talk about trusts. People say, well, it's a way to avoid probate. We're going to talk about that. I put in business transition. We're just going to touch on it. The reason I put that in there, it's broader than just a business. It could be a farm, the family business, because sometimes what happens, well-meaning parents who have an interest in a business or in a farm maybe have an idea of what they want to happen after they pass, but if it isn't put down somewhere in writing, in a document, in an agreement or whatever, it can create a lot of problems. Power of attorney. We will talk about the power of attorney, which we will find is really you giving the authority to somebody else to sign your name and make decisions on your behalf. And then finally, that healthcare directive. There's a whole history behind the healthcare directive. There's a whole process of kind of the emergent of different versions of this document. And the healthcare directive that we have in North Dakota, very good, absolutely a very, very good document. So let's get into some of the issues. As Amy pointed out, I will go through them. Again, some people may think it's a little bit quick, but we're just trying to kind of touch some of the issues. When we get to the end, we'll have some time for questions, and we can go at that point. So first one, income tax. And you'll find a lot of these issues are issues that I have been asked. Somebody comes to my office and says, well, here's what I understand. And when they make those questions or make those statements or offer those questions, it's a key to me that, well, maybe it's a misunderstanding out there, and it's a good thing to put into a seminar. So the first one up there is pretty basic, and it says there's no income tax for a gift. So if mom decides or you decide you want to give your child $50,000, sometimes people say, well, who's going to pay the tax? How does it affect taxes? Well, first of all, if you give your child $50,000, you don't get an income tax deduction for it. Sometimes I've got kids, and there are times when, of course, I really thought my kids should be a big tax deduction for some of the money we spent, but they're not. That $50,000 is just money going out to them. It doesn't affect your income tax, but just as importantly, it doesn't affect theirs. That 50,000 doesn't show up on their 1040. They don't pay taxes on that. We will talk again down the line about how it fits into gift taxes or inheritance taxes. Little different issue, but for our purposes, no income tax. Now, that next one is a big issue. The sale of assets. Income tax upon sale of assets becomes an issue in planning as to how you proceed. So literally what happens is that when you sell an asset, let's say it's a quarter section of land, and you got that 160 acres and you paid a certain amount for it, and now it's appreciated in value, I think you understand that if you sell the property now for that higher value, you're going to pay some capital gains tax upon that sale. But you'll notice that last line, those 3 words, stepped up basis. We're going to talk about that. And here's an example. Now, the numbers I know compared to what we have in North Dakota right now are way out of line, but just use them as an example. Because back actually when I was practicing, I've been doing this now, what, 48 years. So when I was practicing, 70s and 80s, this happened. We're back in maybe the 40s and the 50s. Mom and dad were buying land for $10 an acre, $20 an acre. So that's our example. So dad buys land for $20 per acre. That's called his tax basis. So let's say that the current value is $400 per acre. The next step, most of you probably realize that, but I'm just going to hit it anyway. If dad sells that land, he's got a taxable gain of $380 per acre, which is the difference, what? Between the current value and his basis, what he paid for it. So the 380 is what he's going to pay the actual capital gains tax on. We understand capital gains tax rates are lower than regular tax rates, regular income tax rates, but there is still some tax. The bottom 2 lines, that's where it's important. Many times I will have somebody come into my office and what they'll say is, well, I want to gift that quarter section to my kids. I just want to give it to them. Well, you can certainly do it. Legally, you can give the property away. The problem is that if you give it to them, they get your tax basis, which is $20 per acre. Then they turn around and sell it. They've got the same issue up above. They've got that gain of $380 per acre. On the other hand, if the children take it at death, their tax basis is the value at date of death, you'll see up above, which is the $400 per acre. Now you can imagine if they turn around and sell it at $400 per acre, basis is equal to value. Do they pay any tax at all? No. So think about that. So I'll give you a real example. Happened, it's been now many years ago, but I had, in the spring of the year, I had a family member call me up. Not my family, but a member of a family. What had happened is the year before, their father had been dying. It was a sad deal, I think, dying of cancer. And everybody was all afraid of probate because there's all this vision out there, these theories that, oh, probate, it's going to be terrible, which in North Dakota, it is not. But what they did, let's use the example right here, because that was pretty close back in those days. I think it was a half section of land. So we're talking 320 acres. Dad's basis was $20, current value, let's say 400. And everybody was so worried about probate that what they did is they had dad go into a lawyer and had dad gave the land to the children before he died. Now, as I recall the story, about 2 weeks later, dad died. Well, this was in the prior year. I was getting the call in the spring. What do you think happened? Well, the kids had gone, they had sold the land, by the way. They sold the land, got it all set up. They had now gone to the accountant, and the accountant told them about the tax. So think about this. $380 per acre is their gain. 320 acres. I'm not a mathematician, but you can calculate that out. It's a pretty good size number. That's the income, that's the gain subject to capital gains taxation. If they had waited until dad had passed, their basis would have been 400. They could have sold the land and it would have been zero. Now, I'm not saying that in every single case that your dad wants to hold on to the land. There can be all kinds of issues. I just want you to understand that when you get to the point of making that decision on a gift, it's a big decision. It is a big issue. And many times, again, there's what I call a misperception that, well, it might go into probate and we're going to pay a whole lot of tax. Okay, next slide, look at this. So in the United States, and if you're a North Dakota resident, these are the tax limits. This is the way it works. So back when I started practicing law, I think that the exemption back in the late 70s were like $60,000. Well, what happened was the estate tax, and it's the gift tax and the estate tax we'll talk about is actually tied together, but that we call it the transfer tax. The exemption, you'll see that transition, $3.5 million in 09. 2010, actually, there was no transfer tax in 2010, which meant that if I was, let's say, make me the father, if I died on December 31, there was no tax. But if my estate, let's say, was $10 million and I died on January 1 of 2011, you see that we did end up with a tax again and a $5 million exemption. So think about that. December 31, no tax. If I will live one more day and my estate is over the $5 million, my family's going to pay tax. I always suggest with a smile that if I was that person, when it came to December 31, I'd probably lock the hospital room door so my kids can't get in, because they'd probably want me to die on December 31 rather than January 1. But look at it now. Look what's happened. We went in 2017, and on 2017 it starts to go up with a COLA increase. All of a sudden it's kicking up. Look at 2025. Right now the per person protection against gifting and estate taxation is $13.99 million. And not only that, but each year there's a cost of living adjustment that's going to continue it up. And you think about that. Now that's per person. So if you just take the simple math, if you got a married couple, you want to transfer property to your kids, there's $28 million that you can transfer to them, and you're not worried about estate tax. That's a lot of money, a lot of money. As you can imagine, the number of even people in North Dakota where we're worried about it is very, very minimal. So don't worry about estate tax unless you be in that very unique situation where your family has a good deal of asset level. The gifting here, this is something that does create confusion. I go back to questions. I will have clients often tell me, well, I understand that I can give $19,000 per year. And it is a confusion. It's reasonable. I understand it, but that's not the rule. The rule is you can give away whatever you want. If you have $2 million and you decide I don't need $2 million, I'm going to give my child $1 million, no problem. Absolutely, it's legal to do it. All the $19,000 does is that's the amount that if the gift is $19,000 or below per person, you don't even have to report it to the IRS. I mean, if you think about it, if you had 10 kids and you wanted to give each of them $19,000, you could get rid of $190,000 on December 31 of 2025, not even have to file a gift tax return. On January 1, you could do it again, another $190,000 out the door. No gift tax return to be filed, because that's what we call an exclusion. And that's that word, it's excluded. Don't even count it from the standpoint of the IRS. But you'll notice down below that it says the gift to any person above that exclusion, that then is potentially taxable. But let's go back here. Remember, I said it's a combined tax. So even if you give a gift that's over $19,000, all you're doing is you're reducing your $13.99 million protection during your lifetime and at your death. So it's a combination. So if I give away $100,000 during my lifetime and the gift tax exemption is 13.9, it means that at death I can give 13.8 and still be fine. So here's an example, kind of trying to make it work. So mom says, I'm going to give $59,000 to a child. And let's assume there are no prior gifts because they are cumulative. If mom's given $100,000 a year for the last 10 years, well, that's $1 million that she's used up. It all accumulates. But she gives $59,000 to a child. So let's assume that there are no prior gifts. So again, the first $19,000, what happens? We don't care about it. It doesn't even matter. The next $40,000, in theory, it's subject to tax, but we've got that exemption that we've been talking about. Remember, $13.99 million. And all that happens with that extra 40 is it runs the transfer tax exemption down. We'll look at the bottom. Again, unless mom is one of those ultra wealthy people, it doesn't matter. Because now, with that gift of 59, 19 excluded, 40,000 reduces her exemption, and now what does she have? She got 13,950,000 left over. As you can see, for the vast, I'm not saying that's for almost all people in North Dakota, you could gift away everything you wanted if that was your desire, and it's not going to be taxed. You're not going to pay a tax on it. Your kids aren't going to pay a tax on it. They don't pay a tax on death. It's a wash. And so if you think about that, you go back to this idea that we talked about, was should I gift my property away now during lifetime, or should I figure out a way to get it to my kids after my death? When you look at this example right here, I'm not saying there are no times when it would make sense to gift it all away, but if you look at what we got here, if you gift it, it isn't going to harm you. If you wait till death, your kids get stepped up basis when they sell it, if that's their desire. They're not going to pay any capital gains tax. It's win-win. Now, I will tell you that over the course of time, that idea of that stepped up tax basis, that the children get it at the increased rate, that has been under attack in Congress for years. That it even goes back into the 1990s when they were thinking, well, maybe we should do away with that. The idea being that, think about the revenue. Go back to the example with Dad and the $20 per acre. If you got rid of stepped up basis and the children decided to sell the property, well, that's going to do something for the Internal Revenue Service receipts because they're going to start getting tax. Now, one caveat here, and this is something that I see quite extensively. I didn't write it into the outline, but it's worth discussing, and that's this. This $19,000 exclusion that we're talking about only applies to the Internal Revenue Service. It has nothing to do with Medicaid. Some people say, well, my mom can give away $19,000, let's say to all 10 of us kids, and then she can go on Medicaid and there's no problem. No, it doesn't work that way. This is the Revenue Service. This is the IRS. There's a completely different set of rules for Medicaid. And essentially, just make it real simple, any gift that mom makes in the 5 years before she applies for Medicaid while she's in skilled nursing care is potentially a disqualifying transfer. So 19,000, doesn't matter whether it's 5,000, 19,000, 29,000, whatever it is, Medicaid treats it completely differently than what we've got going on here. Okay, so enough of gifting and taxes. So bottom line is what? Don't worry about the estate tax. It just is a non-issue. The continuation, if you will, was just passed again this year. At times, there was a concern that on January 1 of 2026, all these high exemptions would go away. Congress took care of that this year, and now it just continues on. Cost of living increase, within the next 5-6 years, who knows, maybe 15 million, 15.5 million. It just keeps going up. Okay, so what do we do with asset ownership? Remember I said that that's such an important part of your estate plan, because you truly can you can really plan almost around the need to file a will with the court if that's what you want. Now I'm going to tell you right up there at the top where it's got sole ownership, the rule on probate and wills is this. A will applies to property which is owned solely in your name. So I've got a quarter section of land, it's in my name. If I die, if I've got a will, the will controls where it goes. What happens to the land, what happens to the cash, whatever it might happen to be. If I don't have a will, we'll talk about that. We go into what's called intestacy, and there are rules. But anyway, That gets us into probate. Solely owned property gets you into probate, and typically it's going to be land, real property. It's going to be a house, a condo, whatever it might happen to be. Timeshares. Timeshares are actually solely owned property if it's just in your name. Now, we start to look down the line. Joint ownership. If I have a house, my wife and I, for example, we own a house that's in joint name. When I die, my wife, Patsy, doesn't need to go through probate to transfer title. All she does, she takes a certified copy of my death certificate, and what she does is she takes it down to the courthouse, records it, and she owns it. Bank accounts, same thing. A joint bank account goes to the survivor. No need to worry about probate because it automatically, under law and under contract with the bank, it goes over. Beneficiary designation. A good example would be retirement plans, life insurance, annuities, those kinds of things. If there's a beneficiary designation, that takes precedence. And that's an important point. Let's say that for whatever reason, mom has 2 kids. She makes out a will. The will says, I give my property. In fact, let's use an example. My brother Jeff and I give my property to my sons, Casey and Jeff. Okay, but let's say that on the life insurance policy that she has, she just designated Jeff. Okay, when mom dies, that life insurance goes to Jeff because he was beneficially designated on the policy. Remember, that's not solely owned property. Anything else, if there was a car, maybe a house, that's shared between Jeff and I, but Jeff gets that life insurance policy. If it's an investment account, Jeff gets it if his name is on there. And that's important because sometimes what happens, we do these designations and we don't take the time to step back and try to understand, what does that mean? How does it affect things? How does it affect things? Houses and land. One way that's kind of neat ways that we have here in North Dakota, the life estate. I can set up property and I can say, my wife Patsy and I could say, we transfer our house to our kids, but we reserve to ourselves a life estate, continuing during the lifetime of both of us and continuing until the death of the survivor. Well, if we do that, during our lifetime, we control the property, but now it's no longer solely owned property because we have the kids. They're on the end of that deed. They're called the remainder owners. They really have no rights until both Patsy and I are dead, but upon our death, that property is going to pass to them automatically. Again, they don't need to do anything except take a death certificate, take it down to the courthouse, and they're good. Now, the life estate is a permanent transfer. Once we've made that deed out, those kids have a right. They have an interest in that property. If they die, if one of them dies, you know what? That remainder interest goes into their estate. It's part of their property ownership. Now, the other option is what we call a transfer on death deed. Now, that's a different animal because the transfer on death deed says that Patsy and Casey transfer to the children, and the words that are in that deed say effective on death. Now, during our lifetime, if one of our children makes us mad, we can revoke the old deed, make a new one, because we control it. We control what's going on. Now, the difference between the two is that a lot of times these days, people are talking about nursing care. They're talking about Medicaid. The life estate, if it's been in place for at least 5 years, does offer protection to the value of that property against nursing home expense and will allow you actually to qualify for Medicaid. On the transfer on death deed, because it's revocable, because you could shut it down and sell the house without the need to have the signatures of the children, the law and Medicaid considers that you still own the property. And so if you end up going into nursing care with a transfer on death deed and you need to try to apply for Medicaid, you're going to need to have to sell that house if it's transfer on death. So, but they all work. And both of those, life estate and transfer on death, if you roll them back to the prior discussion, because Patsy and I have retained control of that property and an ownership interest in that property, upon our death, our children get stepped up tax basis. In fact, as I go up the line with beneficiary designation, same thing. So if I've got a bank account, an investment account, and I put the name of my children on that account and I die, they get a stepped up basis. And if there's stock in that account, if it's some type of, again, a bond account, whatever it might happen to be, they actually get that stepped up in tax basis as they move forward. So again, take away from this slide is what? Sole ownership gets you into probate. If you designate ownership with somebody else as joint owners or designate somebody to take the property on death, you then end up with, I guess I call it probate avoidance, which is really our next slide. And that's this whole idea that probate comes with sole ownership. And if you want to avoid probate, what you do is you take everything and you either put beneficiary designation or you take care of it. Let's use an example. Let's say Patsy and myself. And let's say we've got this house in joint ownership and everything else we've got, it's either jointly owned or let's say I've been or designated Patsy as my beneficiary. So upon my death, what happens? Okay. Upon my death, the house goes to Patsy, the investment account goes to Patsy, my retirement account goes to Patsy, the car goes to Patsy, whatever it might happen to be, Patsy owns it all. Well, now what does she do? Well, she's still got those options. She could say that on the bank account, the investment account, she could designate the children as the beneficiaries of those accounts. I do caution people. Sometimes what people want to do is they want to go to that bank account, and so when I die, Patsy wants to put the name of a child. So we have 6 children between us. So she wants to put the name of one of those children on the account. The problem is that if you put a child's name on the account, number one, they're the ones that get it upon your death. But number two, if that child gets into financial trouble, it creates a dilemma is what it does. As long as you put the money into the account, you're not going to lose it. But I've had situations where the child got into trouble and we actually had to deal, with a creditor. One time we actually had to go to court to prove that it actually was mom's money and that the kids had nothing to do with it. And it all worked out, but it's a hassle. So I'm not a big fan. I'm not a big fan of having the child actually in an ownership capacity. I'll give you 2 options. One is most institutions will allow them to have signature rights. They don't own the account, but the bank will allow, for example, the child to sign on the account, and there's a difference. And the other one, which is to me is probably preferable, is what you do is you set up the bank account, and then what you do is you designate the children as beneficiaries upon death. So you own it during your lifetime. Nobody can in any sense, limit your ability to deal with that account. But upon your death, the children take a death certificate to the bank and maybe fill out a paper, and it moves on. Same thing with an investment account. Mom can do that. Let's say the house. What does she do with the house? Well, go back to what we just talked about. She could do a life estate if she wanted to, or if she didn't want to tie it up because maybe she says, I want to sell the house. What she could do is she could say transfer on death deed, so that upon her death, she still controls it, but upon her death, the property passes over. So think about that. If the house is transfer on death, if you've got the bank account, the investment account, the policies, the retirement, everything else designated to the children, the odds are that upon mom's death, you still don't end up in a probate situation. The most important part, though, is coordinate ownership with the plans. And that goes back to the example I think I hit here just a couple minutes ago, and that is where we've got 6 children, and for convenience, maybe one of them is here in town, and we put that child's name on the account. So to go back to the example of Jeff and myself. So let's say my mother has now passed, but for a while, there was Jeff and I and Mom, and we talked about different planning items. But let's say that Jeff was living in Colorado, I'm in North Dakota. What if Mom had put my name on the bank account? And let's say that Mom had a $200,000 house and a $100,000 bank account. Upon her death, if my name's on the account, what happens? I get the $100,000. Let's say that she has a will, and the will says, I give my property in equal shares to my sons, Casey and Jeff. Okay? We share the house. Each of us gets $100,000 there, but I could end up with that $100,000 out of that bank account. So even though mom really intended that we'd split it so each of us would get 150, I end up with 200. Jeff ends up with 100. Doesn't happen often. I have been in those situations where I've seen it occur. I got to tell you, most of the time, the other child says, oh, that is, mom intended that you should share it. I have had situations where the child who got the money said, no, I think that's really what mom wanted. I could look over at Jeff and say, well, you know what? Mom really did like me. And let me tell you, it makes for some very, very tense moments when that occurs. But just be cautious. Be cautious about it. And the other issue we're going to talk about in a little bit is when we talk about businesses. I talk about farms, I talk about businesses, and we're going to hit those. Remember, that's part of the deal. It could be, especially if you've got a child in the business or a child back on the farm, you can create all kinds of problems by not dealing with it. Okay, wills. Simple rule. If you don't have a will and you have solely owned property, so again, I've got a quarter section just in my name. Upon my death, if I don't have a will, the law has a will for me. It's called intestacy. Basic rule is this. If it's the traditional family, you've got husband, wife, and 2 kids, and all the kids are part of this marriage, what's going to happen is the property is going to pass to the wife. If you've got a blended family, a little bit different situation. You know, some of the kids belong to the husband from a prior relationship, some belong to the wife from a prior relationship. Upon the death of one of them, in the absence of a will, it's not necessarily true that the surviving spouse will get it all. There's a formula in the law where the surviving spouse will get some, but the children of that deceased spouse will also be entitled to a share. So it's something you need to watch out for. In my opinion, blended family, you always need a will, or at least some kind of a plan to take care of it. I guess I should back up. Either a will or some type of a plan. So how do we make a will? Again, I know I sound like a broken record, but we're going back to solely owned property. If you've got solely owned property, you need to have something, and a will is the best way to deal with it. What are the formalities? If you live in North Dakota, it's really been eased. It's a lot easier than it used to be. It always used to have 2 witnesses. You know, if you watch the movies, there's always the movie, you know, where the attorney is usually sitting in front of a roaring fireplace, and the people come in, and it's all solemn, and the witnesses come in, and they sign it, and the witnesses sign. I mean, that's traditionally the way it works. In North Dakota now, you can have a will that has been signed and witnessed by a notary public. So I can make out a will. I sign it in front of a notary public. The notary obviously stamps the notary seal on there, and that's a valid will in North Dakota. Now, if some of you are kind of in the border and you're over Montana, South Dakota, Minnesota, for example, Minnesota does not have that. In Minnesota, you need the 2 witnesses. So you got to be careful. Got to be careful what you're doing, where you're doing it, how you're doing it. Sometimes people ask, well, can I do a handwritten will? Yeah, you can. Yeah, quite frankly, if you got I would say a very simple estate, you certainly can do it. The thing is, it all needs to be in handwriting. All in handwriting. I had a situation about 4 years ago. I had a client who actually sent me a copy of a will that he had prepared. It was typed out and he signed it at the bottom. Is that a valid will? No. Because in North Dakota, it's either got to be witnessed by 2 people, witnessed by a notary, or completely handwritten. So I called up the client and I said, listen, you know what? If you want this to work, take what you did right there and put it all into your own handwriting and sign it. Then you've got a valid will. But that's an important point to know. Property transfers. How do you want property transferred? A very common question. People will say, do I need to list all my property in the will? And the answer is no. No, you don't need to do that. Generally, I'm saying, in a typical family will, I might say, upon my death, I give all my property to my wife, Patsy. If Patsy should predecease me, I give my property in equal shares to my children or to all the children. If it's a blended family, name them. I give my property to the children in equal shares. And then there's a choice. Typically, we use the word, you'll see it, per stirpes. P-E-R-S-T-I-R-P-E-S. Strange word, is Latin. And what it means, basically, it passes down. So if we have 6 children and I die and then Patsy dies and there are 5 living children and there's one child who's deceased who has 2 children of their own, Per Sturpus says those 2 children share the 1/6 share of the parent. And that's probably more typical of how things work, but you decide that. But on the other hand, there are many times where people say, well, wait a minute, I want this quarter section of land to go here, and I want that quarter section to go there, and I've got this property over in Arizona, and I want that to go, and you absolutely can do that. You can do money. I want $10,000 to be set aside for the soup kitchen. I want $20,000 for this, or sometimes it's a percentage. I want to divide $100,000 of my estate this way, 25% here, 50% there, 25% there, all kinds of things. So in other words, you can generally put it, which is probably more typical, or you can say, here are the specific transfers, but you're always going to find at the end, it's going to say, anything that hasn't been otherwise designated is divided this way. We call it the residue. Sometimes attorneys call it the residuary clause, and that's typically going to be there. Minor children, if you got minor children, in my opinion, I think you need a will. I do think you need something to handle them. It could be, I think of myself, if my kids had died, or I'm not my kids, if my parents had died when I was 18 years old, and there wasn't a trust set up for me of some kind, I would have taken the property, and who knows? I suppose I would have gone off and skied in Colorado until the money was gone, which probably isn't a very good business plan. So with minor children, number one, to take care of their assets, but number two, also, who's going to be the guardian? Who's going to take care of them? Because if you don't have that designated, you end up with a potential family fight, is what happens. So special issues, we're going to go over to the next slide, and I would call it what I call protective trusts. And so the beneficiary possibilities are minor children. And the other one is disabled persons. A person with an incapacity perhaps is not in a position to handle the money which is going to them, and very often we have trusts set up. So back to the minor children, the choice is going to be how long. I think when I started practicing, it was very common that people would say at age 18, pass it out. I think what's happened is, as the asset level of people has increased, they have realized maybe that is not the best plan for their kids. And so typically, I will find a trust that says any child who's under the age of 25, we're going to hold the property in trust. In the trust that we use in our office, it will probably say something like this. You can use it for their support and their care, their education. If they decide to go to college, you decide. You can say use it in amounts that are reasonable to the trustee. Sometimes we set aside. I've done them where it says you can pay tuition up to a level that's that's equal to that currently charged at the University of North Dakota. Why would you do that? Well, maybe you don't want them to go to Stanford, where maybe it's $60,000, $70,000. What can you use it for? Can you use it for room and board? All those things can be handled in this trust for minor children. Once they're out of college, generally, if they go to college, we set it up and go to college, go to trade school, on-the-job training, all kinds of different things that you can use it for. And then if they're not in training or in school, the trustee still has the discretion to help them out. They're at their first job and they're not making it. The trustee could help them, give them a little bit of a supplement to make it all work. What we do put in our trusts is a provision that essentially says the child can't call up, let's say, Uncle Jeff, who's the trustee, and say, hey, Jeff, put $1,000 a month into my account. I'm down in Florida. Surf's looking good. I'm on the beach. Chill out. Jeff has the right to say, tell you what, you tell me what you're making. You tell me what your expenses are, and we'll get it figured out. Disabled persons, there are 2 factors here. Number one, usually what we're talking about is the ability to help that person use those assets for their benefit. The other time, we have what we refer to as special needs or supplemental trusts, which are set up to allow the person with the disability or the incapacity to go on with life and also to potentially qualify for Medicaid. And so there's certain provisions that are in that trust which would allow that individual to qualify for Medicaid, for supplemental income, for all different kinds of things. Obviously, what can the assets be used for? Timing of distribution. I've had them, typical, very typical one might say, pay it out at 25. Sometimes we do incremental distributions. It says if the child's under 30, hold it. When the child reaches 25, give the child 15, 20% of what's in the trust. Hold the remaining 80% until they reach 30 and then pay it out. I've seen 25, 30, 35. I've done a couple, quite frankly, where the distribution started at age 55. Now, you may think that's kind of wild, but the way it was described to me, and it made sense, the parent was turning it out to become essentially a retirement distribution for the child to allow them to enjoy their retirement. Who's the trustee? Typical choices are either a family member or a corporate. Most banks these days have a trustee. They do a good job. Of course, they charge money, just the way it works. You can have a family member. It's easier now than it was 40 years ago, and here's the reason, is that there are very, very qualified financial advisors, trust companies who could help a family member. So the family member could be the trustee, could turn the investment decisions, or not decisions, but the investment advice over to somebody who's more qualified. And the trustee, the family trustee, then becomes more tuned in to what are the needs of this child, as an example. And a lot of parents like that. They like the family, kind of the family touch as you go forward. Tax trust we don't use quite as much under the new tax law. Used to be we'd use it to try to kind of slide by some of the tax. You're not going to see a lot of them anymore because of the exemption of $13.99 million. Revocable trust. The rage for a while, and sometimes even now, is the revocable trust, and it's usually billed as a way to avoid probate. Now, and I agree, it does avoid probate. I have no problem with it. In some states, if I have clients who have, let's say they have a condo down in Florida, my advice at that point in time is do a living trust, because some states, Florida, to me, prominent among them, has just a very, very complicated and what I see as expensive probate system. And so if you've got a condo down in Florida just in your name, the odds are you're going to end up going through probate. If you have a trust, the trust is intended to avoid probate, and there it makes sense. In North Dakota, I mean, we do them. We do revocable living trusts. We find that most of the time, the client does not really benefit from the additional cost of a trust, because it costs more to set up the trust, transfer the property into the trust. I can tell you from the experience I have not been involved in every state, obviously, but North Dakota has as friendly a probate law as just about any, I'm sure, not just as friendly as anything I've seen. Probate is simple in North Dakota. 99% of our clients never see the inside of a courtroom. You don't need to. Where we go into a courtroom is people are fighting about it. And so if you've got a will that's set out, or if you got your beneficiary designations and all we're talking about is the house, and you've got a nice clean will, what's anybody going to fight about? So remember, if you set up a trust, you need to transfer the property into the trust. The one that comes to examples about 30 years ago, somebody's got this beautiful, like 40-page trust. I don't know how much money they paid for it, but they came in after their spouse died and said, okay, I'm ready to go. I said, okay, so show me the deeds and the titles that say what's owned by the trust. And he kind of gave me a blank look, and I said, well, was the house transferred into the trust? Well, he said, well, no. I said, okay, how about the investments or anything else? He said, no. Well, the trust was basically an empty shell that did nothing for him. If you're going to set up the trust, you either set up the trust and transfer the property into it, or you can set up a will, which is called a pour-over will, and have it go into the trust after death. Revocable living trust, you pay your income tax just as it is. Estate taxes are paid just as they are as if you owned it. Trust does set it up so you can use it in case you become disabled, but look at the bottom. A revocable trust has no protection from nursing home cost. I have had multiple people come into my office and say, well, I've got this trust set up and I don't have to worry about nursing care. And if you look at it, if you can revoke and amend that trust, it is not going to protect you. It is not going to protect you against nursing home cost. That's when we get over here, irrevocable trusts. Sometimes in the past, when the estate exemption was low, it was much lower. We used it for life insurance. A lot of times people are using it for minerals these days, trying to kind of keep it down in the family as it goes through. Other limited areas you can use it for, and sometimes it is. Sometimes you can do it for, for estate planning, for Medicaid purposes. We don't use it a lot, but I just want to touch on it because there are trusts out there that cannot be changed. The family business, we've talked about it pretty much. I think it says it right there in my outline. The first concern is, what about that stay in the business child? It's the child on the farm. There are 5 kids. One of them stayed on the farm and worked on the farm. The other 4 went off to all the different coasts. They're in Virginia and Texas and all over the place. And now mom and dad die. And all of a sudden, this child who stayed on the farm suddenly has 4 other children who own as much of the farm as he or she did. That's the problem with the standard will. And it becomes, how do you deal with it? Should the child who's on the farm have the ability to either get it or a good method to purchase it? I think so. I think it's a fair division. The other thing is, how do you fund it? Sometimes you can't. With the value of land these days, sometimes that farm is worth more money than than the farm child can afford. Well, what about if the other assets went to the other children, or you got life insurance to do it? So that's enough as a touch, because that's a whole seminar in itself, is how do you deal with it? And my point is, just be cautious, if maybe you're the child on the end and you got mom and dad back on the farm now, or you've got a business or you own an interest in the farm, how are you going to transfer it down? And that becomes the issue. Think about it, because there are a lot of different ways that you can do it. Durable power of attorney. The key point is here, the durable power of attorney is something that says, if I want you to sign my name, I can authorize you to do it by a durable power of attorney. The second line or third line there, words of durability, it should say, this power of attorney continues in effect in spite of my disability or my incapacity, or other words like that. Otherwise, before that, under the old law, the power of attorney was no longer any good as soon as the person who signed it became incapacitated, got amnesia, got dementia. So it's got to have those words of durability, otherwise it's no good. You can do gifting under powers of attorney. When I started practicing, the powers of attorney were a page. Then what happened, life gets more complicated. The power of attorney we use in our office, I think, is probably 7 pages long. A lot of people say, well, I'm not going to honor that power of attorney unless I see it in there. The IRS, farm programs, banks, investment companies, they like to be named. They like to see specific provisions in there. We include a provision about gifting in the ones we do. In fact, that gifting could be used, if necessary, to help qualify for Medicaid. Some states, Minnesota notably, if you live in Minnesota, there's a statutory form. It's kind of like check the box. And it says, here's the power of attorney I authorize, and you can check individual, or you can go down to the bottom and it says, I check everything is above. It says you can do everything. North Dakota does not have that. Quite frankly, I'm not sure. I guess nobody asks me. I'm not a person in power. I think it's something we should look at. Many states have it. It would be so simple to do. But for now, you do your own. You do your own. And again, attorneys, because there's no standard form, they're all different. They're all different. I always tell people, if there's a form that is exactly like mine, they just copied mine. And that's just the way it works. But it's important. I think the durable power of attorney, with this time where the medical professionals can keep us alive, is just as important as a will, quite frankly. Because those are decisions. If you don't have a power of attorney, what happens? What if I have a stroke tomorrow and Patsy needs to sell the house and there's no power of attorney, which, by the way, we do have. But if not, she'd have to go to court to get a conservatorship. Sometimes clients think, well, my name's on the house, so I can sign for it. No, you can't. Patsy can't sign my name unless I've given her the power to do it. Power of attorney, very important, very important. And lastly is designate a healthcare agent. Those of you who are old enough to remember back in the early 1980s is when we started to talk about the rights of living wills and the rights of people to say, if I am unable to communicate, here's what I want you to do. It's gone through a whole process. We went through living wills, which said that if I am dying, here's what I want to happen. And then we went to a form in North Dakota, which was called the Durable Power of Attorney for Healthcare, which is still valid, which said that if I can't communicate with my doctor, I authorize this person to make decisions for me. Well, now we finally in North Dakota gotten to what we call the healthcare directive. It's a good form. It's a statutory form. It's not the catch-all. It's not exclusive. In other words, I know that, for example, I think the Catholic faith, I think, has a form for their own healthcare directive. Fine, nothing wrong with that. But if you want the statutory form, it's there. And what it basically says is this: if I can't make decisions, I authorize this person to make them for me. In the forms that we use, it's got that living will language. If I am dying and I can't communicate with the doctor, do I want a feeding tube? Do I want forced nutrition? Do I want forced hydration? What if I'm unconscious but not dying? Some of you may remember the young lady down in Florida who I think had a stroke, and the doctor said, well, if we keep the feeding tube on, she might last for 20 years. And the husband and the parents got into a battle over that. Well, there's language about permanent unconsciousness. And in the form that we use in our office, or offer in our office, it says, you know what, if the doctors say I'm permanently unconscious, I authorize you as my healthcare agent to direct the doctors to pull all of the life-sustaining procedures, equipment, and allow me to die.